very interesting that many persons that did not know what an injunction is, because it is certainly one of the most favorite words for any practicing attorney in the civil arena. It's something really sought after, and it is a relief. So I will start with the textbook definition of what an injunction is. Essentially, an injunction is a grant of urgent interim relief. And that's the simplest form I can put it. And we're using some words there: an order, or a grant of urgent interim relief. Now, what happens?
Go ahead. I was just gonna read some of the comments. So we have Roxanne, Miss Stone saying possibly a temporary order to stop a particular behavior.
I like it.
Placing a stop to action, that's Shahida.
I like it.
And we have Miss Williams saying an order to restrain or compel an action. A restraining order that is supposed to protect a victim from an aggressor. All right.
Nice,
I think we can start with some of those definitions there for sure.
Right.
So go ahead.
So I must commend many of these definitions. They are nice. I like it. I am very proud of members of our public. You all seem to be very informed, knowledgeable. But we want to get it exacting this evening. All right. So I like the first one that mentioned or included the word temporary or temporary. And that's nice. It's another word for interim. I would have mentioned in my definition that an injunction is the grant of urgent interim relief. And so the word temporary can be replaced there with interim, but urgent is the key thing. Oftentimes, there may be circumstances where it's appropriate for the court to take immediate or urgent actions, because save and except for those actions, the claimant may have a high likelihood of suffering harm greater than that of the defendant if it not be granted. And so let's talk about that, because I see other definitions here that may apply, but they are particular to circumstances and situations. I see mention of protection orders, restraining, compelling. The thing about injunctions, Mr. Paul, is as we find it as urgent interim relief. It's relief. It's in fact, we often term it injunctive relief. It is a civil remedy to provide an ease, right, for the person requesting same. Now, someone used the word compel as well, which ushers us nicely into the different types of, the two main types. Mainly, you have either the court using an injunction to restrain a party from doing something, and that is referred to as a prohibitory injunction. So we're restraining you, or you're refrained from a particular action. That's a prohibitory injunction. Or it may be commanding them to do something. You must. And that's termed a mandatory injunction, when you are compelled to do something. All right? So those are the general two categories that they will fall in. Now, most importantly, in my definition, I would have alluded to the fact that an injunction is an urgent interim grant. Interim meaning that it is for the time being, until trial occurs or until the matter is heard. It is not something that extends for a long time. The court generally grants an injunction to either prevent or force an action in order to give the court time in the assessment of the matter. Right? Usually injunctions are granted before trial, because you may have something happening. You know that trial takes a long time to even start. You have pre-trial review, you have filing of submissions. Well, I know you all may not know that, but that's what happens. All right.
Wait. I just want to kind of slow down a little bit of slowing down there, because there's some things you would have mentioned that because I work within the administration, I understand, but I didn't understand before that, and you've given us a lot of information so far. So I would like to start with, first of all, you mentioned that it is a civil situation. Please define what that means and I would nudge you in the direction of comparative with other potential litigation.
Right. So the only other thing it could be is criminal, right? So civil or criminal, right? And so those are the two, usually these spheres are low. When
And family.
No, a family still will fall under civil, civil practice, civil procedure, right? Civil, so in law, there's civil procedure, there's criminal procedure. In order to differentiate where a remedy falls, if it's a criminal remedy or a civil remedy, is usually, the criminal remedies would be incarceration, jail, bail, these kinds of things, right? Or you will have to pay a fine. When you hear the words, so in criminal, when money is passed, bail, fine, these are the words would be used. Or it's imprisonment, incarceration, indictment. That's criminal. Those are the words for that. Remedies under civil will be damages, compensation, costs, relief. That's where you get injunction. You don't get relief necessarily in a criminal manner. Now, there may be, and we have seen in the bigger public law, because you now have public law arena, where there may be an injunction used, and later on it's an indictable criminal matter. I don't want to confuse people with these things. However, generally, injunctions are used within the civil litigation arena, where you are going to get redress by virtue of trial, but something is happening before trial can even start, and you need them to stop now, or you need them to start doing that now. So either to start or stop, but that injunction forces or compels to action.
Right. Now, so thank you so much for that, because it really helps us differentiate certain matters, right? Now, you would have kind of sauntered through the process of the injunction, or you have to file this and all. Can you kind of walk us a little bit through? Because sometimes, we go to a lawyer and a lawyer might say, all right, this is injunctive, and then you expect him to go to court tomorrow because this is this is urgent. Could you kind of set our expectations in terms of
I would love to. I would also love to set your expectations in terms of everyday attorneys get things that are urgent, right? Everything is urgent. Everybody matter is urgent. Everybody house always on fire, right? So that is one thing. I like that you asked that question. You need to remember two things. The court decides and also determines if the injunction would even be granted. So you may come to an attorney and this is your claim and this is your situation. And to you, it is the end of the world. It is the most important thing happening and you need relief now. You need to understand an attorney at law cannot confirm or guarantee your injunctive relief. Injunctive relief has to be decided by the court. Now, it is something usually, as I said, it's urgent. So when an application is sent in when we file for an injunction, it can happen overnight, within 24 hours, 48 hours, the court may do so. However, the grant of an injunction has to be satisfied by certain things. The court makes an assessment, right? And in making the assessment, what they do, as I said earlier, that they will consider the likelihood of harm to be suffered by the claimant without the injunction, if it is greater in both likelihood and in extent than the harm that will be suffered by the defendant if it were granted. And in making that assessment, the court will consider the strength of the claimant's case and his likelihood of success at trial. They will also consider the severity of harm that both parties will suffer and the extent of monetary damages that would be adequate compensation for such harm. So what we mean by that, Obviously, so I don't want to get into protection orders because that's something very different. That's harm to life. We're talking here about injunctive relief for matters pertaining to personal chattel or property. So let's say someone is doing something to destroy, bulldoze your house. You and your neighbor have a dispute, and they find that the extension to your home built
Right.
is
Blocking the
over
view.
their invisible boundary. We are giving some real life situations. And they say, you know what, I fed up corridor, Mr. Paul. Today, I'm mashing it up. He is on my land. Now remember, boundaries are something that they are invisible, as we had in earlier webinars, the survey would have highlighted. Boundaries are invisible lines. They don't depend on feelings of who you feel on your boundary. Now, that is a claim that one party is making against another that has not yet been determined. One party is threatening to do something or may have started. He may have rent his bulldozer and start to mash up your place. In that instance, your attorney may certainly advise you that an injunction is appropriate to either stop your neighbor immediately from action. In the meantime of filing the application or the claim before the court, which are two different things.